Okay. Ms. DiFiore,
Yes.
have at it.
I'd like to reserve 5 minutes for rebuttal, though I honestly doubt if we're going to need them. So this is one of many appeals in which FIGA was ordered to pay a consolidated settlement in which the attorney's fees were included in the indemnity. And a settlement agreement is reached before the insurance company became insolvent, but never paid. And then the plaintiff has to seek to enforce the settlement after the insolvency. As this court is aware, FIGA is not responsible for statutory attorney's fees under 627, I'm sorry, 627428, sorry about that, unless FIGA has affirmatively denied the claim. Obviously, if a case is settled before it comes to FIGA, FIGA's never affirmatively denied the claim. So the settlements, the orders in which the courts are requiring FIGA to pay the statutory portion of the fee are being appealed. And FIGA is asking for a written opinion to provide guidance in this area because we have been getting conflicting PCAs. When I'm the appellant, I get PCA'd, and when I'm the appellee, I get PCA'd. And so it's a little hard to know what we're supposed to do with this. I will be candid with the court. I was in front of a different panel of the Second District Court of Appeal just maybe 2 weeks ago. We asked for a written opinion. They PCA'd me a week later, affirming
The written opinion said affirmed, right?
Yeah, exactly. It just PCA'd. So once
Ms.
again,
DiFiore,
yes.
does the settlement agreement specifically refer to 627428?
No, it does not. We have had some that did.
Are we sure that it distinguishes between the award for the claim and attorney's fees under 627428?
So
Can we be sure of that?
complaint, the complaint asked for fees. They're entitled to fees anytime there's a payment after suit is filed. The driving force behind 90% of the first party property litigation is the attorney's fees. But there is nothing that specifically says these are fees awarded pursuant to 627428. However, when the fee agreement breaks it out, then it becomes attorney's fees and it becomes a fee that FIGA is not obligated to pay.
You mean when the settlement agreement breaks it out?
Exactly, when the
Right.
settlement.
So the way this is structured, it was a $90,000 settlement. Please cut two checks. One to me.
No, actually, it was
or three.
90,000 to the client, 20,000 to the lawyer, and then
In addition to the 90.
right, and an additional amount for depreciation.
Right.
So it did not specifically say one big number, and here's how we'd like you to break it out. At least not that I
Okay.
found in the record. If Mr. Battisti has something in the record, then I missed it. So, but yeah, we have many of these. Some of them are clearly a global number that they then break out, and you can almost calculate the mathematical precision of a percentage. Others are actually the attorney's fees are significantly higher than what the client gets. So, in my perspective, that kind of a settlement is a little questionable to see that as a percentage of recovery. And in this case, again, 20,000 out of 90 doesn't seem like a typical 25%, 30%. It seems much more consistent with the amount of work one would do on an hourly basis. The problem is we don't have a lot of evidence. So the courts make assumptions that I think go outside the four corners of the settlement agreement, which is basically breaking it out by fees. There's sometimes in these cases, there's testimony that it covered this, that, or the other. I don't believe there was any of that in this case. And it's just a matter of the court saying, well, you reached a settlement agreement. And in this case, we have a problem because the court's ruling was based on a case that was actually overturned. They decided that FIGA had to honor the settlement agreement because FIGA assumes all the obligations of the insolvent carrier. But the Soto case was expressly overruled by the Florida Supreme Court in the Petty opinion. And so the court appears to have misunderstood the standard. FIGA does not simply step into the shoes of the insolvent carrier. If the insolvent carrier is obligated to pay statutory attorney's fees, then FIGA does not owe that portion of the settlement. Petty and Soto being overruled make that very clear. And in this case, the court appears to say that the Soto ruling was the controlling point. So she seems to believe that these were statutory fees that were being paid by the insolvent carrier and that FIGA simply owes that obligation. We
But you
attempted to draw her.
got two things wrong there.
Right. So we attempted to bring this to her attention in a motion for rehearing. She did not wish to change the nature of her ruling. She just made it final so that we could seek the appeal. But we believe clearly if you think this is a statutory fee and you're relying on a case that's been overturned, then that needs to be corrected. In all candor, FIGA would just like some direction. If this court is inclined to feel that this was a division for purposes of convenience, maybe some guidance to FIGA that says when it's clear that it's a division for purposes of convenience, then it's a FIGA responsibility. But when it's clear that it's a statutory fee, or if there raises any indication it's a statutory fee, like when the fees are significantly exceed the amount the client is recovering, or when the settlement says it's a statutory fee, then either there's got to be evidence to show it's not a statutory fee, or FIGA can't be obligated to pay it.
Well, let me ask you this: is it necessary that it has to be a statutory fee in order for us to affirm? In other words, isn't the corollary, the converse, or the other side of the coin that it has to be a covered claim?
Exactly. So in
other words, what if it's not a statutory fee? What if it's a side bargain on? The point is, it has
Or
to
just
be covered.
this is just the fee you owe the attorneys for doing the work.
Exactly, and that
I
would
mean,
not be covered by the policy.
It has to be covered. It's not so much that it has to be a statutory fee. It just has to be covered in the policy.
Right.
But it's part of the, it's paid out of, the parties agree to pay it out of the global recovery, right?
Right. So when you say, well, I'm entitled
This
as
is
a
like-
plaintiff, as an insured, I'm entitled to 50,000, but I want you to give 20 to my lawyer, then
Right.
that would probably be a covered claim if in fact the insured is entitled to the 50,000. But when there's no discussion of any of that, it's this is coming to me, and it's very rarely. I have had cases where the amount recovered was more than the invoice, and then that's obviously a statutory fee. I wish we could have these as simple. But when there's a number that's less than what they've been asking for, and there's no indication, then I think there needs to be something that the court relies on to determine whether or not it's a statutory fee or it's a covered claim or
any fee fee
right.
that is being, but
Right.
because the problem is that, if you got just a number and it's not a statutory fee, it's not, they're trying to stick FIGA with it, but I'm going to owe these attorneys this, like, you get an insurance settlement, generally, and it'll be made out to the attorney or whatever. You don't want to have the position where FIGA is able to deduct the fees that the claimant owes his or her attorney. I mean,
FIGA's got a little bit
frankly,
of a
on its face, that's kind of looks like what this is.
So FIGA has a little bit of a concern. The legislature went to the trouble of protecting FIGA from paying non-covered claims like fees. So FIGA does not want to appear to be ignoring the legislature's protection for them. And if the court feels that, just as you've discussed, this was the insured's money, it's being divided up for sake of convenience. If that's the way the court tells FIGA that it needs to be, that makes it a little bit easier. But at this point, we feel like the legislature is looking at FIGA going, we gave you a protection and now you're voluntarily paying all these settlements without clearly establishing it's a covered claim. But again, I do think there are exceptions.
I mean, should we be worried about how FIGA looks to the legislature in our interpretation of the law as complied to the facts of the case?
I don't think you should, but I do think getting a clear ruling solves the problem. Okay. And that's all that we're asking for is, but we also need a ruling that shows that there are differences, that there is all of its indemnity, that there's indemnity plus a contract obligation, and then there's a statutory fee. And
of course, you recognize that when we write that opinion, every settlement is going to be a total number, and the settlement's not going to break it out with instructions to write 2 checks.
So let's keep in mind that this
if we rule in favor of the appellee and write an opinion.
So let's keep in mind that this is FIGA. So we're only talking about things that have already happened, or it wouldn't be here. So no one's going to be changing that. But you're right. Future insolvencies, that's what they'll be doing. Yes.
That's what they'll be doing. Yeah.
And they'll be making it more clear that it's a one-time lump sum indemnity number and I'm paying my attorney. The problem we have is that there was so little clarity that FIGA is left with the concern that they are depleting the funds of the insolvent estate to pay claims that are not covered. And so getting clarity on that makes everybody's life easier. Quite frankly, FIGA does not want to be paying me to appeal 25 and 30 of these things. They want to have an answer, and it might get rid of all the other appeals, because if you can provide a clear guideline of when it is FIGA's obligation and when it's not, that will probably end up almost, again, I have, I don't know, maybe 15 or 16, and I think Miss Klein has another 10 or 12. So, I mean, we have a lot of them. Not what happens are these insolvent carriers, they begin to settle things very rapidly when the money's running out. So we get a lot of these pre-insolvency settlements that have kind of come along these lines. If the courts need to conduct evidentiary hearings in order to determine if they're covered claims, I think that we'd like to have that guidance as well. So we feel like in this case, there was no clear statement that this is global. And so it's a please pay my lawyer, which makes it sound like a contractual obligation or a statutory obligation rather than a policy obligation. So that's not.
Well, it's going to be a contractual obligation of the claimant.
Exactly. And so is that a covered claim? Oh, no, not under the Florida statute.
Well,
But the question is
yeah.
whether the parties decided to, as a matter of negotiation, to say, well, what was it, 90 grand or something? Yeah, 90 grand. It's all, yeah, it all represents what you think we should have covered.
Right.
But knock yourself out, pay 20 of it to your lawyer.
And again, if the record contains clear evidence of that, I think that's one thing. I don't remember seeing that in the record here. Again, Mr. Battisti was handling it below, so he might do better with the record than I do. But that's our position. Again, I've reserved 5 minutes, but I don't think you guys need me to keep going. So
All right.
I think we all understand the issue. So
Thank you, Ms. DiFiore.
thank you.
Battisti. You're muted. Still muted. Is there you see a microphone looking thing down at the bottom of your screen?
He had it fixed a second.
Yeah.
Twice. Here we go.
There you are.
Sorry about that. I really apologize. Been through enough of these
Yeah.
where I shouldn't be making those kinds of mistakes. Your Honors, if it please the court, I'd like to address a couple of things that counsel said. First of all, arguing that perhaps the judge got it wrong and somehow erred in her decision. In the motion for rehearing, the opportunity to argue the petty case and the overturning of the SOTO and all that was all flushed out. Both sides had plenty of time to argue and go through. I think the court was more swayed on the idea that petty was distinguished from our circumstances. So just as a general practice, we plead attorney's fees in the event that a statutory fee becomes liable. That only happens when there's a verdict, or sometimes there's a case that's resolved through appraisal, which only addresses the benefits. Therefore, the only way to get those fees would be the statutory fee. But
Or
most
confession
of
of
our
judgment.
cases settle. And most of our cases are pursuant to the contract that we have with our client.
Or a confession of judgment.
Or a confession of judgment, but generally speaking, insurance companies don't want to do a confession of judgment for the amount of benefits because they don't want to deal with the attorney fees on the end. They don't want to have a fee hearing and all the additional costs of that. So generally, they won't turn over any money unless they are getting a full release of all the claims, including any potential statutory fees. These are negotiated in a global way, always.
But
because
doesn't
our
that just,
fees are
but you
always-
said
once it's- sorry.
you're saying that the fees are included then?
Well, it's part of the claim that they want to dismiss.
Right.
Well,
So-
just,
we were
reading the release that was, given,
Mhm.
it describes a global settlement of 90,000, 70 to the client, 20 to the attorneys, and then 13 for recoverable depreciation, right? So it does not describe statutory attorney's fees.
No.
It just says take the 90 and divide it these two different ways.
Yeah, if you want to pay your lawyer, do it. And it's pretty commonplace in our industry that the checks are broken out. It's just a convenience thing. It's one, I don't have to go through my trust account. My clients don't have to wait that much more for the money. It gets dismissed faster. It's pretty commonplace that the checks are going to be brought out, but the cases are negotiated in the global way. And I don't have, for me, I'm not being paid our fees right now. I can't use 627-428 against anybody to say that I'm entitled to some statutory fee. I can't use it against FIGA, and I can't use it against my client. My only basis for fees in this case is my contract with my client. It's the only basis that I have, because the statutory fee never triggered. Whether I pled it or not doesn't matter. It didn't trigger in this case.
The effect, you would argue, of ruling for the appellant here, for FIGA here, would be to essentially allow FIGA to deduct the fees that your client is contractually obligated to you for, as opposed to failing to cover statutory fees.
Well, they would basically be invalidating. First of all, our case is a little different even from petty, that we have an actual signed release, executed valid release. I haven't seen any other cases that have actually addressed an actual signing of a release. They promised to send us the checks, told us they were in the mail. We never got them. And then we get the notice that they're insolvent. So what FIGA wants to do is, number one, invalidate the settlement agreement, which is a separate contract, completely separate. And they want to invalidate our client's claims, our contract with them.
Well, so they don't step in the shoes. So it's not your contract with FIGA. So the fact that it's a settlement agreement, walk me through why it's so important that it's a settlement agreement. I mean, the issue is, I don't understand why it makes a difference that this is a settlement agreement and petty it wasn't, except to the extent that potentially it creates ambiguity about what the basis, what the global amount was. In other words, if it, and then I want to wonder who on appeal has the obligation to convince us of what that global number meant. But let me just to be long-winded, but take a step. So whatever the global number is, the only way this comports with petty, presumably, is that the global number is what the insurance company owed for the covered claim. And as a matter of convenience or among negotiating parties, the plaintiff or the insured said, I need to pay my lawyer. Could you just break out some of this money that we're agreeing, we're releasing your insurance contract liability for, another the covered claim. So how do we get there? Am I understanding it correctly? And how do we get there on this record? Well,
Again, there's no trigger of the statutory fee. It is a settlement.
But why does it have to be a statutory fee? This goes back. Okay, whatever. The point is, there's the other side of the coin to me matters more, which is it the covered claim? Is that 20 grand? You have to say, prove to me. I'm not talking about burdens or right now. I'm just saying your argument has to prove that the 20 grand was for the covered claim and just for convenience was broken out. And say, well, I obviously can't keep all of it because I paid my lawyer. I hired a lawyer.
Mm-hmm. Well, for one thing, the total amount sought in the complaint was less than the global settlement, including everything. So the benefits alone that were being sought was less than the total settlement. As far as petty goes,
well, what was the invoice amount? This is an assignment case.
It was 105 and change plus interest.
That's the invoice. What was the invoice that Synergy? So
I think you're saying the settlement was less than the invoice,
right? Including fees, including the whole global thing was less.
So you're saying you got a release that says total settlement for consideration of $90,000, and I want you to, instead of giving all of that to the client, cut a check for 20 of that to the attorney because I'm going to owe that to my attorney.
Yes.
Versus the settlement is for 70, and on top of that, the attorney's fees are 20, and you have to pay that too. That's not what the release said.
Right. And in a settlement where they say the benefits were the full 105, but the settlement was for 130, it would be kind of hard to argue that some of that was not fees. But in this
Right, but
case,
here it's the
below.
opposite, it's the other way around. And if FIGA were to prevail here, essentially it gets to deduct from what it owes the fees that your client owes you, not the fees that the insurer owed you.
Correct. Correct.
So I do agree that it would be a lot easier case for the insurance company if the invoice were for 100 grand and the global settlement was for 120, and they said, hey, that 20 goes to the insurance lawyer. That would make it a lot easier to draw the inference that it's fees. But this is a settlement negotiation, so you know, isn't this gonna be pretty common? It's not often that a settlement is for the entire amount sought in the lawsuit. They're saying, well, we don't think we owe you 100 grand, Synergy. We think we owe you 50 grand. It doesn't cost that much to put on a roof or whatever Synergy does. And they're going to be in the middle. So that doesn't resolve the question about whether 20 grand of the 90 was, insurance. It was fees based on, the statutory insurance fee provision or something other than the covered claim.
Yes, but the statutory fee is not part of the policy anyway. They can.
I agree. That's the whole point. If that 20 grand represents what the parties understood to be, well, yeah, if we would have won, you would have owed us for fees because we would have prevailed, then that's not a covered claim.
Well, but it is a covered claim because they accepted the loss. They paid the full 90,000, less than what my client even wanted. They only ended up with 70 plus the depreciation, which was another 13,000. But they settled it less for the purpose of getting the case resolved. There is always a negotiation if you're going to settle it. The insurance company is not going to settle this case.
Let me, and again, this maybe your oral arguments educate the judges sometimes. I admit it. So maybe I need education. But what if, the invoice is 100 grand, the insurance company says that's way too high. We don't owe you that much. We think 50. You meet in the middle at 70, and then we're going to settle for 90 because, maybe we might have been liable for fees in the end, or we're just going to pay your lawyer. That's part of the settlement. In other words, why is the 90 ipso facto all a covered, part of a covered amount when it's a negotiated settlement? I mean, why do we just presume that the parties understood that all 90 is for, what you should have paid, what the insurance company should have paid as part of the coverage, but we're just going to break off 20?
Well, because we have an executed agreement where the insurance company deemed that their amount to pay was $90,000. It doesn't matter to them whether the attorney gets paid or not. If there's a release, I can't hit them for additional fees. They don't settle these cases if they just pay me the benefits. They always want to get everything resolved, a complete release of any and all claims, bad faith, all of it, or they're not going to settle the case. Their goal is to get out from under it. That was the amount that they determined it was, $90,000. That was the cost. Now, I can just tell you, generally speaking, and in this case specifically, I was involved in these cases. We negotiate on a global level. Whether there's an understanding, whether there's fees involved in that, we negotiate on a global level. The FIGA statute specifically says fees under 627-428. We didn't get fees under 627-428. We got them under an agreement, an executed release, pursuant to our client simply taking some of the money that they received in this case and forwarding over to us to satisfy their obligation. As far as it not being a third, that happens a lot. That's a negotiation that my client and I have after the settlement. And that's when we come up with a number and we tell the insurance company, this is how we want the checks divided. Again,
that's one more thing about, so I'm following you. So one of the things about what might be a tipsy coachman argument, you conceded, correct me if I'm wrong, that might be too strong a word, that the argument in the trial court was that petty was distinguishable because it was a settlement agreement. But I don't believe the argument was advanced that maybe it was that no, this whole 90 is for a covered claim?
Well,
And if so, the question is this. I mean, you obviously, it would be tipsy coachman argument because you're not the appellant. You don't have to preserve it. But is there evidence in the record for a tipsy coachman argument? There has to be evidence of that this 90 was all for a covered claim.
well, I mean, we have potential emails and such. They were verbal negotiations. I can just tell you from our perspective, the settlement was global. I also want to have on the record that the reason why we distinguish petty is petty allowed for an entitlement to go forward against FIGA. So it was an actual claim against FIGA. That's entirely different from them paying a settlement. There's no, if this just said 90,000, there would be no way for them to tell how much the fees were. If they have a right to come in and rewrite settlement agreements like they are trying to do here, what's to stop them from taking every claim that they get that might be settled for and just deduct 1/3, regardless of whether that money went to the attorney or not? All they'd have to say is, well, your contract entitles you to 33% or 40% or whatever it is. So we're going to assume that that's the amount.
Which was the basis of my prior question. That what FIGA is asking to do here, from your perspective, is to deduct fees that your client owes you as a matter of your contract versus a fee that has been awarded or would have been awarded under 627.
Right.
So, and I don't know how these things necessarily work. Do you have evidentiary hearing? Is this going to be like, are these cases in the future? And maybe Ms. DiFiore can respond to this too when she comes back. Is it going to be like litigating a hospital lien, and you're trying to figure out what part of a settlement was, one category versus the other, to which the lien can apply? You're going to have those kind of evidentiary hearings every time now?
Well, yeah. And one of the reasons that you agree to a settlement is to stop judicial proceedings, stop
Right.
costs, stop all of that.
But
If you get a settlement, now you've got to go ahead.
To rule for FIGA here is going to invite an evidentiary hearing every time they decide that some part of it might possibly have been for fees. Correct?
Exactly. Because if a ruling for FIGA is going to change the way people settle cases from now on, they're not going to break it out. They're not going to take that risk of having it broken out. They're just going to say global number, and then
there's going to be no direction about how to cut the check. I mean, just cut the check. Ironically, the check will be cut to the attorney for the trust account, right? So
right.
The check won't, or maybe made out to both, but
right.
Yeah.
I think I'm pretty well done. Again, I just, if you were to rule in favor of FIGA in this case, my client settled the case in good faith, thinking they were going to receive a certain amount of money. If this is granted, then they're going to lose another, whether it's 20 grand or whatever it is they determine to pay us for attorney's fees, is going to be less. They're not going to be held back in the same position they were when they executed this settlement agreement. And one of the charters in FIGA is to make sure that claimants are made whole and not given undue delays. We had to wait 1.5 years to get their money.
Let me ask you this: is it possible argument that you've waived this theory that the whole 90,000 is actually a covered claim, and that or is that squarely argued in your initial brief? I mean, in your answer brief? I guess you're not. You can't. I mean, you're not the appellant, so I'm just.
Right.
I just don't. I'm just
we can bring a
familiar
tipsy coachman without it ever being argued, actually.
Yeah, right. Yeah, that's right. So that goes back to my earlier point about whether there's evidence of record for tipsy coachman. And with that, I will stop asking questions that make me appear to have lost the thread of who is the appellant and appellee.
Right. So you're finished, Mr. Battisti.
Okay. Thank you, judges.
Okay. And Ms. DiFiore.
Thank you, Your Honor. So I think there's a couple of things Mr. Battisti said that are not really consistent with the law, but I don't know that it matters in the long run. But one of the things he said is only ways to get fees is through the verdict. And I think the court was quick to point out that no, if there's a settlement that doesn't expressly say it's including fees, it will trigger entitlement to fees. So it isn't just a verdict, it is in fact a settlement. In fact, any payment, I've had represented insurance companies where they accidentally paid because they didn't know suit was filed, and it's been deemed a confession of judgment and obligated them to pay statutory fees. The other idea is that they did in fact ask for statutory fees, and in his own words, he said the in settlement includes the potential statutory fees. One of the biggest,
but I think maybe what he meant was the release included any claim to statutory fees. This was a complete release, correct? And so they've given up any other claim they have.
well, they're giving it up. I agree in that release,
And
but the settlement contemplated that there could have been statutory fees awarded. And so what might have been a $50,000 claim had to be paid at $90,000 because it had to include the statutory fees.
What you're suggesting, though, then is what I asked, Mr. Battisti a few minutes ago. Are you going to have an evidentiary hearing every time to have a court apportion the settlement amount? And say,
I don't know that it needs
this number was because there might have been a claim for statutory fees. I mean, I'm not sure FIGA really wants to do that, correct?
So I don't know that it needs to be
How would that look to the legislature?
full-blown evidentiary hearing, but I do think they need to have something, like if affidavit from the insured or something from the attorney, something, but they don't produce anything. They just file a motion and say it's your obligation.
Right. What you have here is a release that says $90,000.
And 20,000 of it's for attorney's fees.
Cut the check these ways. I mean,
and again, I think that we're, in the words of the young people today, I think it's delulu to say that the settlement did not involve attorney's fees.
I like that. What if the release had said, make a check for 90 plus the 13.8 payable to Synergy and the attorneys?
So that is
actually what FIGA have done with that.
That is sometimes, if it had been a one full check at $90,000 that did not break it out and included everybody, I do think FIGA would have paid that. Yes.
But if it's paid to the order of both the client and the attorney, the attorney, obviously some of that's going to be attorney's fees.
One would, or costs. Yes.
But FIGA's not going to drill down and say, tell us, we're not going to pay all of this because some of it clearly is attorney's fees, right?
Exactly. It's when it's specifically allocated and identified as attorney's fees that FIGA feels that it's clearly stated to be a non-covered claim at that point. Because again, whether it's by a contract or it's by the statute, it's not for the claim that was covered under the policy. It's now paying an attorney, which is not a claim. And the important thing about Petty isn't that it talked about entitlement versus settlement. It talked about what is a covered claim. It must be a claim that's brought under the policy and within the terms of the policy. And this is not, there is no coverage for attorney's fees in these homeowners policies. There are coverage for attorney's fees in other policies. I represent those policies so that attorney's fees can be covered claims, but it's not what's in these first party property claims. And so Petty does not relate to when the entitlement or where or how. It's simply that under the policy issued by this insurance company, attorney's fees are not a covered claim.
So the only difference between a $90,000 check, a release that says paid check $90,000 payable to the attorney and claimant, and this situation is that it says write two checks.
Exactly.
But it could have been the same amount of attorney's fees owed under the contract between the claimant and his or her attorney or its attorney.
And again, if they can come in and show that that is in fact what they agreed to, and I don't really see it as a whole lot of evidence there because FIGA doesn't really have a whole lot to come back against it with. But again, if it's over the
I'm not sure if FIGA has a whole lot to come back against the language of this release.
So, well,
but
the release clearly says it's an attorney's fee.
No, it doesn't. It says pay to the attorney. It doesn't say it for fees. Could be, hey, the attorney lent me money a year ago, and it could have been that.
You're saying that, Ms. DeFiore, you're saying that the release says it's for everything to include attorney's fees, but the the payment amount, the description of the payment amount does not say it's for attorney's fees. It just says cut this part to the attorney. Is that?
I think that's a much more eloquent way to put it than I was saying. Yes. But
There's a
that's
first time for everything. I'm teasing.
So, you know, it does expressly say we're including the attorney's fees that are owed. And then it says, and this is how much they are. I mean, that's when it's a global settlement, and it's up in the first part of the release. It says it includes the amounts for benefits, interest, blah, 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 all that kind of stuff. And then they say, and so here, let's break it out. But they already said it's inclusive of fees.
Yeah, but you know, obviously the insurance company is going to require the language about fees because they don't want to leave any potential claims outstanding. Correct.
Agreed.
Right. All right. So anyway, we've gnawed on this bone long enough. I think our time is up.
And we, again, I cannot emphasize enough that a written opinion would be incredibly
So
helpful.
this is the case. You want this opinion in this case?
Well, you know, Judge Sleet
Are
asked
you just randomly asking all your panels, or you just want?
Yes, actually, I am. So Judge Sleet asked me that the last time. He goes, really? And I'm like,
Really?
again, if you can give us guidance, I think even if I'm going to lose, I would like to have the guidance. But he apparently didn't think it was worth it. So.
All right. All right. Thank you both very
Thank you
much.
so much. I appreciate
Thank you,
it. Have a
Judge
great
Sleet.
afternoon.
Thanks.
In order
everyone.
to leave, you have to click the leave button over in the lower right-hand side of your screen. Thank you. Our last case on the docket